If you'd like to earn CPE credit for listening to this episode, visit earmarkcpe.com. Download the app, take a short quiz, and get your CPE certificate. Continuing education has never been so easy. And now, on to the episode.
Hello, and welcome to Oh My Fraud, a true crime podcast where our cases involve capital acquisitions instead of capital punishment. I'm Caleb Newquist.
And I'm Greg Kyte.
Before we get into today's episode, Greg, I would like to read a listener email, if I may.
Sounds great.
Great. This message comes from Jim Park, and Jim says, I'm a law professor at UCLA Law School where I teach securities regulation. I was delighted to come across your podcast and am especially looking forward to catching up on the episodes on Miniscribe, the salad oil scandal, and the Four Seasons fraud. About a year ago, I published a book on the history of securities fraud and its regulation that may be of interest to you and the listeners of your podcast. It was definitely of interest to us, Greg, so much so that he is our guest on today's show.
Yeah. And now, just to set our listeners' expectations correctly, hey, listener, don't start thinking that you can just butter us up with a sweet email and you'll automatically get to be on the show. But also, we still do love to get buttered up with sweet emails, so please do consider to continue to send those to the show at ohmyfraud@earmarkcpe.com. Keep them coming. We love to read them. Our low self-esteem kind of needs that.
Yeah. Flattery will get you everywhere. Now, that being said, we would love for anyone who has been convicted of a fraud and been sent to jail for that said fraud. If that's you, then send us a shitty email. And if your case is interesting and we don't feel that our lives are in danger, then we'll consider, putting you on the show.
Yeah, that's a disguised invitation to Jeff Skilling to reach out to us.
Yeah, no, we would. I would totally talk to Jeff Skilling.
I'll reach out to him.
Please do.
Hey, another thing, Caleb, before we get into today's interview, we do need to lay just a little bit of groundwork because we want to make sure that the show is accessible to everybody. Yep. So first off, during the interview, we do throw around the acronym GAP. As if everyone knows what GAP is.
That's just for the uninitiated. That's GAAP.
Exactly.
Not the mid-range clothing store.
Where you mean the place where I buy my jeans always?
Yes,
not
and
that
all my t-shirts.
Yeah.
Yes.
So we throw it around like everyone should know what it is, and that's probably because we feel like everyone should know what it is. GAAP stands for Generally Accepted Accounting Principles, and basically if you're a publicly traded company in the United States, you have to prepare your financial statements in conformity with the Generally Accepted Accounting Principles GAAP of the United States of America. So there's that.
Well said, Greg.
Thank you.
Also, if you are new to the show, we do mention a couple of cases that we've covered in previous episodes. Those are Four Seasons Nursing Homes of America and Miniscribe. Four Seasons was episode 10 and Miniscribe was episode 21.
And with all that being said, we are so happy to have the following conversation with Jim Park, who's a law professor at UCLA, and he's the author of the book, The Valuation Treadmill: How Securities Fraud Threatens the Integrity of Public Companies.
So, Jim, thanks for coming on the show. I was so, like I said before we got on the mics, I was so pleasantly surprised to get your email, and so it's great that you're here. We like to start off these interviews with just getting people's stories. So, start way back. Like, were your parents securities attorneys? Like, give us the Jim Park story.
Yeah, I mean, they had nothing to do with securities. I don't know if they even invested in the market, and I myself never really got into investing until maybe after college or even after law school. And, I grew up in Ohio. I'm a Midwesterner, and, sort of a science guy initially. And I was on the debate team growing up, and that got me interested in law. And I studied economics in college. Had this great professor, James Brock, who taught antitrust, and he had this great class where we would just read these books on big business and companies like IBM, and just the sort of the stories of businesses that had grown too big and they ended up not doing so well, and just the approach of that class, I think, really got me interested in just sort of the narratives, just sort of the background, the history of business and economics. And he recommended some great books to me that I still look at today on corporations. One is The Modern Corporation by Burley and Means, which is this classic story about how there's a separation between ownership and control in the modern corporation that is kind of the basis for a lot of corporate law debates today. He gave me a book called by Joseph Schumpeter on sort of this idea of creative destruction in corporations. And so he got me interested in studying big businesses and corporations. So I went off to law school and took a great business associations class, learned about corporations there. Had an internship at the Securities and Exchange Commission, and that got me interested in corporate law. Then I started working in New York City in 2000, and so I did a couple of federal clerkships. I was out of the city on 9/11 between clerkships. I worked in the federal courthouses, which were 5-10 minute walk from there. I was at the World Trade Center, just a week or so before the attacks. But I was out of town that day, and that second year I was in very close by the ruins, and just a sort of a formative experience. So then I think I go on. I work at a law firm for a couple years. That's around the time of Enron files for bankruptcy, I think, in the fall of 2001. And then WorldCom's about 6 months later, Sarbanes-Oxley in 2002. Then I'm entering practice around that time. There are a lot of these securities frauds that are out there. We're defending a lot of SEC investigations, private lawsuits. Did that for a couple years, and I switched sides, and I went to the New York Attorney General's office. Who the AG was Elliot Spitzer at the time, who was known as the Sheriff of Wall Street, and I worked in the Investor Protection Bureau there. I was fairly junior at the time, and a lot of the biggest cases had been brought, but there's a steady stream of really interesting work going on that I was a part of, and I got to work on some accounting fraud investigations against big companies, and so I got a sense of how that worked. So, after that, I was there for a couple years and thought, why not go into teaching? That's something I'd always thought about. I taught at Brooklyn Law School for about 6 years, and then got the opportunity to come out west to UCLA, where I've been for about the last 10 years. And so given my background, it was natural for me to study securities fraud. And so over the years, I've written a lot of articles on private litigation, on SEC enforcement, and that's all culminated in this book, which is a history of securities fraud and securities fraud regulation.
Right. And before we get to the book, just a couple of questions. Well, first off, just to point out, it's a debate team. That seems like that's a clear path towards a profession in the legal area. Have you found a lot of your colleagues are like, yeah, debate team that's what got me started too?
There are a lot of them, and it's just a great activity. It really opened a lot of doors for me because it's, my parents were not lawyers. They didn't really have any knowledge of this. And so this is kind of the way I got to understand how to, construct an argument and speak in public. And, I see a lot of ex-debaters out in the legal world and in legal academia as well.
Yeah, the good ones. I did debate when I was in middle school. Not a fan, and so hence not a legal profession was not in my future. So Jim, tell us more. I had no idea that a SEC internship was in your past. Can you tell us more? Like, what was that like doing an internship at the SEC? Were you like, please tell me you were kicking in doors and hauling off bankers' boxes full of receipts?
It was a little less exciting than that. I think, actually, I misspoke a little bit. I think the internship was before law school. Now that I think about it, is between college and law school. And it was really interesting because I worked in this office called the Office of the Inspector General. And I don't know if you've heard of the Inspector General. I think every agency in Washington has an Inspector General who's supposed to kind of audit the agency, make sure it's doing a good job. And so the project the Inspector General was working on is he was doing an audit of the ethics of SEC lawyers. And so I got to go with him. I was kind of the note taker. I traveled all around visiting the different regional offices and listening to SEC lawyers talk about their jobs and why they did what they did and ethics more generally. And that got me interested in public service because, I learned that there are all these folks here who could be making a lot of money at a law firm, and they're making a government salary in order to do this sort of work, and that sort of blew my mind. Just sort of that idea, and also that they're doing more interesting work in some ways than maybe at a law firm in some cases, and they also have the option to kind of go back and go back and work at a law firm later on after they've sort of built up a name for themselves, and that got me interested in working in government.
Right. So, and then another question. So that you said you spent a couple years at a law firm before you got into teaching at various law schools. And I assume, just based on what you said, just to make sure I'm clear on this. So, did that law firm specialize in? Because you said you defended a couple SEC investigations. So, was that the specialty? Was exactly that defending? Like companies would come to you, say, "Hey, the SEC's coming after us. Help us." Is that what you did?
Exactly. That's part of what I did, and it's a very big practice in law firms now, where doing white collar investigations and defenses of SEC investigations, cases by federal prosecutors, and there's a lot of this stuff also that it never becomes public. You never know sometimes that an investigation is happening. But lawyers may be working on it, and so it just sometimes oftentimes the corporation calls the attorneys to kind of work out sort of what happened within the company. Like they sometimes want to identify who did the bad things, and so it is a huge practice area for attorneys, and so I did that kind of work. Also did some litigation in courts where you're actually being sued. And they also did some corporate litigation. So I did some work in Delaware, which is sort of the leading place for corporate lawsuits and leading place where public companies incorporate.
So, okay, so that's interesting. When you said a lot of, so let me see if I'm getting this picture right. You're saying that a lot of times the SEC will come to a company and say, "You're in trouble." And the company will be like, "What the hell did we do?" And they'll come to their attorney and go, "We don't even know what the hell we did." So it's almost like you have to do because we know about forensic accounting. I assume you had to do that to go backwards to go, "Oh, here's what they're talking about." Is that it?
Absolutely. I mean, a lot of the folks who are, working in this area, they may have been former SEC employees, they may have been federal prosecutors, so they know how to investigate a company, and they sort of use those skills to help the corporation know what happened within the company, so they will talk to people, interview people, read a lot of documents, sometimes before a case is even filed, and so then the corporation can decide what it wants to do. It may decide, hey, let's just settle this, or let's fire these individuals and cooperate with the SEC. Or sometimes the corporation and its attorneys will try to persuade the SEC or the prosecutors not to even bring a case. And some of the most successful results are ones where there was an investigation, and or by the SEC, and you persuade them not to go forward, and no one ever hears about the case.
Right. And that's probably the most valuable thing that could, like, the most positive outcome that could happen for the company that's being involved is if you're good enough to just tell the SEC, you need to just, there's other things you need to be focusing your time on. Is that right?
That is the best result, and it happens.
Cool. Yeah. Wild. Okay. So then, so now getting back to your book, your book is called The Valuation Treadmill. It's all about securities fraud. And I know throughout the book, you'll go back to the concept of the valuation treadmill. Would you just explain to us and to our listeners what it is that you mean by the valuation treadmill?
Yeah, I got the phrase in part from this book on valuation by McKinsey that I would highly recommend to anyone interested in learning about valuation and finance. And, their description is that if you're a public corporation these days, that in order to maintain your valuation, to keep your stock price just at the same level, it's sort of like running on a treadmill where you have to continually be moving forward just to stay in the same place. Because as a corporation, what you're trying to do is you're trying to convince investors that your future performance is continuing, that, as you know, the value of a stock is going to depend upon the market's assessment of the present value of the company's future earnings. And so it's important to persuade investors that trajectory that they have based their valuation on is continuing. And so that requires doing things like consistently meeting your projections of quarterly earnings and revenue, also maintaining fairly ambitious projections of revenue and growth. And the thing that distinguishes a public company from a private company, in my view, is you're subject to this short-term pressure, as many of you know, where you have to deliver market results consistently, or there could be a very rapid and brutal reassessment of your valuation, and your stock price can plummet. And I thought the idea of the treadmill was kind of a nice sort of analogy that, you just have to keep moving forward just to stay in the same place. And, there's a quote from the book about, one of the frauds involved equity funding, which is about 10 minutes from where I am in the 1970s. They basically make up insurance policies to boost their revenue. And at one point, the staff, the managers, they tell the CEO, you have to stop. We're going to go to jail if they discover this. And his answer is, I can't report flat earnings. I can't report flat earnings, or there's going to be a reassessment. And part of the point of the book is those pressures, you start seeing them kind of in the late 60s and 70s, and they kind of build upon each. It sort of builds over time to the point where you need a law like Sarbanes-Oxley to kind of counteract that pressure. That's the idea of the valuation treadmill.
Cool. I love it. And I've seen enough videos on TikTok of people who stop running on a treadmill and just get tossed against the back wall that I think I'm on board with the analogy. So yeah, awesome. So Jim, then the next question, and this relates very closely to what you just explained, is it has to be with like the motivation. You as accountants, we're beat over the head with the fraud triangle. I'm sure you know the fraud triangle. There's got to be opportunity, pressure, and some kind of way to justify your fraud to yourself. And so with the pressure, what I'm wondering is, just if you would tell me if I got it right, how the pressure comes for securities fraud, because I see it coming from two ways from where I stand. First off, it's the people in the C-suite that are at least, the people that we look at as committing these frauds, and they for sure have to have lots of stock in the company or stock options in the company for themselves. So if they do commit securities fraud to maintain or to increase the stock price, they're going to directly benefit from that because of their stocks or their stocks options. The second pressure is that if and I guess even like what you said, if the stock price either drops or even if it just stays the same, that's going to start pissing off your shareholders, and shareholders can vote out people who are management for a company. And that's what I see as being the motivation for this. Is there anything I guess two questions. Is that right? And is there anything I'm missing?
That's absolutely right. And the book tries to emphasize, I think, the second explanation, because the first explanation is one that's been sort of written about a lot, just the personal incentive of executives to sell their stock. And I think that's true in many cases, but not all cases. That, I think the thing that makes it complicated is that sometimes you have these securities frauds and the managers, they're not bailing out of the stock. And they are trying to kind of make things work for what they believe is the good of the company, the good of the shareholders. And I think that's what is a trickier type of securities fraud than just sort of this idea that it's just bad people who are trying to enrich themselves. And, it links in very nicely with sort of this idea of shareholder wealth maximization, which is being increasingly questioned in modern times. And part of the rise of the problem of securities fraud, I argue, is this idea of shareholder wealth maximization, which kind of gains more traction in the late 60s, 1970s or so. Before that, there's a sense like corporate managers, you're like kind of a pillar of the community, a captain of industry that is taking care of this large organization that has a huge impact on society. And part of that is enabled by the prosperity after World War II, where U.S. companies are just thriving because they have no, competitors. The rest of the world is recovering from World War II, and they don't need to commit securities fraud because they are, they're raking in money basically, and they have no competition. Right. It's when you kind of get the more foreign competition and technology is disruptive that you begin thinking about, well, what about the shareholders? These managers are lazy, and that kind of leads to this shift in various respects. And part of that shift involves changes in the way we value companies, where we're looking much more at the projections, and that really becomes more prominent, like in the late 60s and 1970s or so, where we're saying we don't entirely trust you managers. We want to see, are you meeting these benchmarks? And by the 80s and 90s, it's really kind of the driving force of stock markets, where it's quarterly projections. And you read the Wall Street Journal today, every 3 months, every story is about, did this company meet its projections? And that's a type of shareholder wealth maximization. And the interesting thing now is you may be aware is that we're seeing more questioning of the focus on shareholders and concern about stakeholders. So it'll be interesting to see how that affects the way we regulate public companies. But it is exactly right that I think it is sort of this broad idea of shareholder wealth maximization and showing that you're maximizing shareholder wealth by meeting projections.
Right. So almost, just to make sure I'm understanding what you're saying, it sounds like, sure, the whole I've got stocks, and if the stock price increases, then I become more wealthy. That's his thing. But what you're saying is there's this weirder, more nebulous, harder to just say you're a bad guy kind of thing, where really what the motivation for some of these guys is they just basically want to do a good job, which means we need to see that stock price go up, which means we need to hit our projections. And the projections, are those internal projections, or are those the ones that like analysts, external analysts say, hey, we think you need to meet this to hit this? Where do those projections come from, inside or outside the companies?
It's mainly the external projections.
Okay,
but
that's what I
the
thought.
interesting part of the story is how did we begin relying on external projections? And part of the reason is that internal projections start getting better at some point in the 50s and 60s. And part of this is that we're beginning to see management more as a science, and people are going to business school. They're being trained to kind of manage their large organizations, and that's internal projections, like setting good internal projections. Part of it's also technology. You have computers; they can keep track of things. And so what happens sometime in the 1950s and 1960s, markets start getting more interested in those internal projections. And that's why they begin thinking external projections are more reliable, because these analysts are often getting information from the managers about their internal projections, right? Sometimes it's kind of through side conversations. Sometimes the companies will release their own projections. And the reason we begin to try, think about it, it's kind of crazy to think you can project a company's future performance out in, it just seems like kind of an odd thing. But that's sort of what managers are paid to do, is to manage the business and to have reliable projections. So what happens gradually over the 60s and 70s is that this becomes sort of the way we judge managers, right? And if you're missing your projections, that tells me not only the company sort of faltering, but the managers are not doing a good job because the projections were unrealistic. And so the irony of this is that, projections become better because managers are better, but then this becomes kind of the way we grade them. We grade them in the 60s, 70s, and even today, based on their ability to sort of accurately predict and meet these projections.
Gotcha.
So I pulled a quote from the book that I think kind of summarizes this pretty well, and you wrote, public company securities fraud is not solely caused by corrupt managers acting to enrich themselves, but is often committed by generally ethical corporate managers who issue a misleading portrayal of the corporation as they pursue corporate goals. So I guess where my brain immediately goes to is what jumps out at me is the misleading portrayal of a corporation. So if you take that as just maybe someone's opinion, right, as a manager's opinion, and is it possible for that to be fraudulent? Like, how do we distinguish between an overconfident CEO or a CFO who's given a rosy outlook between someone who's committing fraud? Is that possible?
Yeah.
I think that's what makes it really tricky, right?
It makes it very tricky, and that's why the law in this area is very difficult to explain to just sort of somebody who's not a lawyer, and even internally among lawyers themselves. There's a lot of disagreement about whether somebody's committed securities fraud, because it depends upon, to some extent, fraudulent intent. There's a rule called Rule 10b-5, which you may be familiar with. This is kind of our Swiss Army knife of securities fraud enforcement that is brought with respect to a lot of different types of fraud. And it doesn't define fraud very precisely. And it's done on a very case-by-case basis. Now, opinions, generally, to the extent that they are pure opinions, the law tries to say that a pure opinion is not going to be enough to trigger liability under Rule 10b-5 or other similar statutes. What gets you in trouble is if you are misstating factual information. Now, the line, though, between fact and opinion can be very blurry. And that's what we look for as lawyers is, can we say this is a misstatement about a fact that you knew was incorrect, as opposed to your general opinion about what's going on? Now, projections more broadly are a form of opinion, right? If I say that, I think we're going to earn this much in a year or two, we generally think of that as kind of being someone's opinion. It's not a fact because it's a prediction about the future, but and there are these what are called safe harbors that have been passed. In 1995, there's a law called the Private Securities Litigation Reform Act that was passed after Silicon Valley gets really upset about being sued all the time whenever their predictions of great success are not met. And so they lobbied Congress to pass this law to provide some protection for forward-looking statements and projections. And it's very difficult to establish liability for opinions or projections. And so what the attorneys, the plaintiff's attorneys in SEC often do is they'll try to find facts, though, that are incorrect relating to the projection, as opposed to saying the projection itself is false. But every once in a while, though, the safe harbor says that if I know the projection is incorrect, that can actually lead to liability, which sometimes happens from time to time. And I was, thinking about your episode on Four Seasons nursing homes, right? Part of, I think, the allegation there was that they just knew these projections were completely unreliable. They were just made up of nothing. They were just had no basis for them. And so sometimes you can get liability for projections, but you usually need to link it into some factual information in order to have a good claim. And the classic example in the accounting statement is that, you claim to follow GAAP and you're not following GAAP, right? And that's something that is kind of, you think of that as not an opinion, but it's sort of a sort of a statement that you're either objectively following GAAP or not. Although I know there's a lot of gray areas, but if I'm egregiously violating GAAP, then that is something that's a misrepresentation.
I'm glad you mentioned the Private Securities Litigation Reform Act, because that caught my eye too, and that was in response to a Supreme Court decision that kind of like, I think, what did you say here? You said it increased the duty that companies had to issue truthful disclosures. And then, in a relatively short order, this new law came out during the mid 90s. And I thought to myself, oh, that's corporate lobbyists earning their keep right there. Like that seems to be, how the sausage gets made, how the legislative sausage gets made in that case.
Yeah.
Yeah. The Supreme Court decision is called Basic versus Levinson, and it made it easier for investors to bring a class action. And if I can bring a class action against a company, then I have a lot of clout because I can allege hundreds of millions of dollars of damages instead of $5,000 or $10,000 individually. Right. And so then you have this rise in these cases, and there's a story of the Apple case where they get hit with $100 million verdict in a trial arising out of their failed Lisa computer and the Twiggy disk drive there. And so they're part of it just Silicon Valley lobbying. And it's a very powerful constituency. And more recently, about a decade ago, there's a law called the Jobs Act that was passed that tries to make it easier to do an IPO, and you can link that pretty directly to very Silicon Valley groups, and that is how the sausage is made. And as a country, we like entrepreneurship, and politicians like getting donations from the technology industry, so that sort of can get legislation passed.
So another question that I have is from your experience, who's actually committing the fraud? Is it the guys in the C-suite? Because I know that they're the ones who are held responsible for it, but I also doubt that a lot of CEOs have the accounting and financial expertise to actually do whatever happened to make and especially, I mean, the biggest thing that comes to mind is Enron, because I've watched all the documentaries. I read the 400-page book, The Smartest Guys in the Room. If somebody said what happened at Enron, I'm like, I think I understood it once and now I don't again. So is it the CEO, the CFO who are committing the fraud, or is it more that they just get everybody in a room and they're like, hey, everybody, sit down and shut up. We need to hit these numbers. I don't care how you do it, just do it. And then that's and then the fraud still comes back on them because they're the ones who were pushing it, even though the other people did the actual, Rube Goldberg machine to make the fraud happen.
So really, it's a really great question. And, to really trigger sort of major SEC interest or even federal criminal charges, high-level decision makers have to be involved to some extent, right? If it's just lower-level people doing bad things and nobody knows about it, then it's much harder to say it's securities fraud. It may just be a fraud, or kind of maybe it's something else. But and it differs. I think you get both situations, and sort of the example you give of somebody not knowing the details might be Bernie Ebbers at WorldCom, where he's not an accountant, and he is basically refusing to make adjustments to very ambitious, projections to the market, and he kind of just implies to the CFO, just do something to get this done, right? And that's
Right.
what he
Yeah,
testifies at trial. He doesn't know really the details of GAAP, and that's true for most high level, especially the CEO, is they're not experts in accounting, and so the challenge in these cases for the regulators is you have to link it to a broader motivation as to why upper level management wanted this to get done and the things they knew about it. And so in the Enron criminal case against Jeff Skilling, one of the things they pointed out is they pointed at very particular small transactions in the criminal trial, even though this is a multi-billion-dollar problem in terms of accounting and so forth. But they're pointing out transactions that are 10, 15, 20 million dollars. And one of them that comes to mind is this transaction with Nigerian barges. You may recall that they're selling these to an SPE, and it's maybe 15, 20 million dollars. And so why are they doing this? Well, what the prosecutors say and the appellate court agrees with is that they're doing it to meet a target, a projection, even though it's a small transaction. And there's also testimony that Skilling is personally involved in this particular transaction. And the testimony that Andy Fasto gives is that the CFO is that Skilling basically said that the SPE would not lose money on the transaction. And so you could argue that it's not a true sale. It's not a sale because Enron has kept the risk of loss on this. And so it's that type of information that you need to sort of bring a criminal case. And you can debate as to whether or not that's sufficient for criminal intent. I think there's probably room for disagreement on it, but these are the kind of transactions that persuaded the Fifth Circuit Court of Appeals to affirm these various convictions. And so sometimes you do have the executives, they're kind of directly involved in some of this, but that's probably the rarer case, I think. And so most of the time it's just like they need it to get done. They need to tell this story to the market, and they basically kind of make sure it's done. They're kind of reckless. And that's mostly just kind of civil liability that gets you in trouble with the SEC as opposed to criminal liability, but sometimes it can be criminal.
Right. So tell me if this is right or wrong, because I like the whole thing of, hey, like you were saying, Bernie Ebbers at WorldCom, he says, hey, here's these projections. I don't care what you do, you just got to hit the numbers. In the legal process, is that similar to when when someone when a lady hires a hitman to murder her husband? She didn't pull the trigger, but she went to the guy and said, hey, murder my husband, so she's guilty of murder. Is it similar to that kind of thing?
It's similar. It's sort of a type of criminal recklessness or willful blindness about kind of the implications of your actions, and it's it is a similar concept, I think, that we've seen in some of these cases.
Okay, cool.
Hey, Greg, should we get into a case or two? I mean,
Absolutely.
Okay, yeah. So the one, so for people who haven't checked out the book yet, check out the book. But it is a history of securities fraud, as I think we said up front. And there are cases. You start with Xerox because correct me if I'm wrong, but you said Xerox is kind of like the blueprint for all future securities frauds to come. And that's why you kind of open with that. And I was somewhat familiar with the Xerox story, and it's relatively straightforward. The one that I wasn't familiar with was Penn Central. And I don't know if Greg, if you knew that particular story, and I don't know how many of our listeners, but it's an older fraud. It goes back to the 60s, and Penn Central was kind of, it was a conglomerate. It was a massive conglomerate of its day. And but it started with the merger of two big railroads, the Pennsylvania Railroad, I believe, and the New York Railroad. Again, keep me honest here. But that was an interesting case to me because the way you kind of lay it out is like you had these historically very successful businesses, railroad businesses, And they started expanding. They get bigger and bigger and bigger, and then they start growing. Instead of growing organically, they start growing through acquisition. And then all of a sudden, they just have this behemoth conglomerate that isn't really a railroad company anymore. It's a railroad company, but it's also a real estate company, and it's also they've got Six Flags, which I didn't even know Six Flags was around in the '60s, but apparently it was. But the thing is like it kind of reminded me of one of your later examples in the book, which is General Electric, which we may or may not talk about. But you just have this massive business that, and again, this is coming out of the age of managerialism, right? Where you've got these smart guys, and they were at that time probably literally all guys. You had these smart guys at the top that were seen as smart and knew how to run a business, a big business, and you just knew that they were going to make it grow somehow. And Penn Central essentially disproved all that because the business got to such a size and scale that it became unmanageable. Is that more or less right? And I'm just curious, what are some key things out of that story that you think people should know about? Because I think it's kind of it's a lesser known story, I would guess.
Yeah, I think among our generation, definitely lesser known. If when you talk to older attorneys, though, they know Penn Central because it was a sort of an iconic event that kind of really shattered faith in managerialism, and so how could such a large corporation run by strong managers go under? It led to questions about where was the board of directors, how did corporate governance work? It was a shock. It was a shock to the system, and it was accompanied by some of these other, Four Seasons Nursing Homes was actually around this time, a smaller company, but one that had committed accounting fraud, equity funding, which I talked about earlier, was around this time. And that leads to kind of a crisis in the accounting world about, where were the auditors? That's the other question that comes up there.
That's a question we ask all the time.
I mean, we're still asking.
It is getting better, but I think it is sort of an everlasting question. But it really kind of, I think, begins at least being systematically asked in the 70s after these crises. And the merger in some ways was very interesting because it was criticized when it was being considered because they said this is going to create this big monopoly it's going to dominate the marketplace. But it's really kind of more of a sign of weakness because you think about by the 1960s, you have the interstate highway that's been built, air travel is cheaper. This is kind of a declining operating business. And so, this is kind of, in a sense, a way of trying to stave that off by combining these two businesses and getting operating efficiencies. And so they're trying to prove to the market that they can do this. They can kind of turn around this business. And so one of the things that's notable about Penn Central, not only the size, is that the strategy of management is let's try to maximize shareholder wealth. Let's try to really do everything we can to create the impression we're generating revenue. And this is also kind of evidence of this new ethos in the 1970s of shareholder wealth maximization as a strategy. And their strategy is they sell a bunch of assets. As you said, they're this conglomerate now, and they're selling these assets they bought in better times. And some of that is completely fine as a way of managing earnings, right? GE, as you may know, during the 1990s, it would sell these, to meet their projections. They would, they sell an asset to someone and just kind of make it right over the line. And everyone kind of knew this and said that, that's actually good management because you're delivering smooth earnings. And Penn Central, so that part was not fraudulent. There were some transactions that were problematic and that they were not quite really sales because the Six Flags example, for example, where they're selling the Six Flag amusement park to a partnership, and they keep the risk of loss. They have this side agreement to keep the risk of loss, and that's very similar to what we just said about Enron. And this is kind of the tactic that gets used over time. And there's this fascinating exchange where the auditors, they don't defend the substance of the transaction; that they say it's not material, and that's another big concept that is worth emphasize. I'm sure auditors talk about materiality a lot. Lawyers talk about it, but maybe thinking about different things. And so they say it's not material because it's like it's raising $30 million. It's $1 billion company. And this accounting professor, Abe Brilloff, who wrote a number of great books in the 70s about public company accounting. He taught at Baruch. He says, well, the point is that the reason it's material is that, without this, you would have reported a loss in a period where you predicted a favorable showing. And so you were kind of meeting this projection. And so that was something that the SEC cited and emphasized in its report. So you're beginning to see some of these little accounting tactics that are emerging around the time of Penn Central. And you're right, it's very, similar to the sad story of GE, where you have this, there's a sort of pattern. One of the patterns of securities fraud is that this company that was once great, it's declining. It's trying to hide that from investors. And that's one of the stories we often see in securities fraud.
Right. I'm in my 50s now, so I'm declining, and I'm trying to hide that from everyone. So I personally understand where that comes from.
You're doing it gracefully, though, Greg.
Thanks. Sometimes it doesn't feel like that, but I appreciate the pat on the back. But Jim, this is something that you mentioned with regard to Penn Central is something that I actually wanted to ask you about. Chapter 7. You began that chapter with a quote that said 78% of the surveyed executives would give up economic value in exchange for smooth earnings. And the reason that came up is you said Penn Central, you kind of commended their management that they were actually at one point they were doing things to actually have some smooth earnings. But can you unpack that quote for me? Even like, what the hell does that mean? Like, what do we mean economic value for, like, are we saying I'd rather have a lower share price as long as I had smooth earnings over a consistent period of time? What did that quote mean? Because I couldn't completely grasp it.
Yeah, no, it's a famous study that's cited widely in the finance literature and among law professors, and it's a bit controversial, right? There's some questions about sort of the methodology and how many people they asked, but the general idea is that they are doing things that are inefficient in order to create smooth earnings. They are, one of the sort of classic example of this is that I'm cutting R&D in order to reduce my costs to deliver stronger earnings. And that would reduce economic value because I'm less likely to discover that next groundbreaking drug and or product. But I'm willing to do this in order to meet the projection, in order to meet market expectations. And the thing that's troubling about that is corporations, in a sense, are playing this game where they are just creating the appearance of doing well, while making decisions that actually are reducing their value over the long run. And I think that's the implication of that study. And it's some academics believe that is a big problem in the U.S. Others think it's overblown. So there is some controversy about that point, but that's also a motivation for what might be questionable manipulative activities.
What's your opinion? Do you feel like that there actually are managers of companies who are very much over, they're flushing great ideas and things that could end up becoming a big deal for their company just so that every quarter they can show just this little tick that the market expects?
I think it depends on the context. I don't think that the problem is a big problem for all companies. And, I think the biggest sort of place where it may be an issue is you have a company that is sort of trying to establish itself and it's trying to show and prove itself. It's not proven to investors. And so it feels like it has to kind of do all these things to create a certain trajectory that kind of makes investors excited. I think it's probably less of a problem for the Googles and Microsofts of the world because they are so dominant that I think that they have a bit more leeway in order to, they have such strong businesses that, hey, we might we might make a mistake here and there, but investors trust us, and we're not going to really kind of make really bad decisions because of that sort of pressure. So I think it kind of depends on the context. I think, the story of the company that's just trying to establish itself, prove itself, that's where I think you may see these sorts of problems of short-termism that could be an issue, and also the declining company, right? If you have these companies that they look great on the surface, but they're declining, that's where I think you can get this sort of value-reducing activity. And I hope it's a small percentage of public companies, but it could be fairly large.
Yeah,
well.
you mentioned, I think it's in the introduction to the book that you mentioned Under Armour, which I think is the perfect example of the kind of the company on the rise, right? Because you had at that time, Nike is like the biggest, flashiest name in town, right? And Under Armour is kind of this emerging brand, and they have great products. People love their products and they're buying it, and they're kind of on fire. But I don't remember the exact details, but they had quarter after quarter after quarter where they're hitting earnings. But it eventually, the streak ended, and quite spectacularly. And the company is fine. I think what's also interesting is a lot of times these companies that are under this pressure, they are trying to meet these expectations because, again, they're on the rise. And if they just sat back and said, hey guys, if we miss one quarter, we can take the hit for a week or two. The stock price can probably take the hit for a week or two. Ultimately, we have strong unit economics, or whatever it is about our business. We feel confident in our business. We can take the hit 2 or 3 quarters. Nobody's going to care, and everything's going to be fine. And as far as I know, Under Armour's still a very fine business, very successful business. And they decided to, play the system, game their earnings. And they paid the price, but ultimately they came out the other side. And so I wonder, so that just brings something up for me. If you do have a strong business, especially a business that's kind of on the rise, it's emerging. If they're in kind of this growth mode, if they can afford $100 million fine from the SEC, or maybe they can even weather some, private litigation, civil litigation. I mean, do you think there's a cost benefit going on behind the scenes where somebody's like, well, we can be super aggressive and we might have some litigation, we might have some fines and stuff to handle with, but it's worth us hitting our numbers, to keep hitting our numbers quarter after quarter. I mean, is that kind of the calculus that has to go on behind the scenes?
It's fascinating. I wish I knew. I wish I was a fly in the wall at Under Armour to figure out, because you're right. They, did they really need to do this? And, I think different companies handle it differently. Others in that situation may have just taken the hit and said, we don't have to continue this impression that we're growing by 20% every year. We'll still survive and still do well. Others, they'll make bad decisions or are deceptive in some way. It's really, it varies a lot how people respond to this pressure. And sometimes you would have been fine, and the sad thing sometimes is that you have these situations where the fraud, it adds up over time, where you just kind of get into this trap where it sort of it gets larger and larger because you're continuing it, and then things don't work out, and you're left reporting a really big loss, and to some extent you could say GE is a little bit like that, and if they had turned things around, no one would have ever known. And that's why it's kind of so tricky, is that I think sometimes the company will say, we can kind of hide this and we think things will just turn around, and no one's ever going to know this, right? No one's ever going to know the questionable things that we did. And you're not going to find that. It's not going to be punished. And so that's why when it is found, when it does result in bad consequences, I think that's why you need to bring the cases, levy the penalties, sometimes bring criminal cases to kind of establish that it's not okay. I think and so it's tricky because it requires a lot of managerial judgment, and I think they are sometimes doing sort of a cost benefit analysis.
I just want to quickly point out, out of curiosity, I looked up Under Armour stock price. It's actually down about 65% over the last 5 years. So I don't recall the exact timing of when the enforcement action came. So like there are long-term repercussions, even in a case like, again, Under Armour, you see their products everywhere, right? But at the same time, from a corporate value standpoint, like the valuation standpoint, there is maybe they're clearly off their peak. So there definitely are consequences. So anyway, sorry, Greg.
And part of it is, do you trust the managers anymore, right? If you no longer trust the managers, you may, that could be a problem.
So a lot of what you were just talking about with GE, was a question I had about Xerox, because in the Xerox case, and this is not, they were accelerating the recognition of revenue. That's I want to say that in probably my first financial accounting class ever, they were like, or audit classes, like, this is the biggest thing that anybody does is revenue recognition. Are you timing it properly? But you pointed out something that's very, I think, very basic to that whole strategy for hitting your numbers, is that if you say, well, we don't have enough revenue this quarter, but how about we take some from next quarter and we sort of push it into this quarter, and then it's like, oh, well, then crap, next quarter comes, it's like, well, crap, now we even have a higher number we have to hit this quarter, and not only do we have to hit that, we also have to exceed it by so much to make up for whatever we pulled out of this quarter for last quarter, and then you have to pull out more from the following quarter, and like you said, it's like it snowballs and it gets out of control. And but one of the things that you said that I thought was this is the heart of my question. You said if they had turned things around, nobody would have ever known. Do you think anybody's actually done that? I because if you're struggling to hit this quarter's numbers, but you go, man, next quarter, I swear next quarter we're gonna so destroy the numbers next year. It doesn't matter if we pull something into this quarter, we're totally good. Do you think that, we'll never really know, but in your opinion, do you think that has ever actually worked?
It's a great question. I mean, you are cannibalizing the future, and that's what Xerox did, sadly, and it is something that you kind of wonder what their thinking is, and if you're if you're charitable to the managers, what you would say is that they genuinely believe there's going to be a turnaround, that there's going to be an uptick, and that they are right to kind of manage
right.
expectations. I bet though, I bet it happens though from time to time, because it has to, because it just it's the way that entrepreneurship works, is you never think this thing is gonna work and be successful, and just suddenly it takes off, right? And I think that's the mentality of not only entrepreneurs but sometimes corporate managers, that we're just gonna get it done, and sometimes miraculously it somehow works, and that's kind of the tricky thing about securities fraud, is that if you impose too much liability, you might deter folks from taking these risks and really as they say in Silicon Valley, fake it until we make it, and that may be okay for private companies. I think though for public companies, it's something that I think we've sort of said we probably don't want that so much. I think that's what Sarbanes-Oxley is about, is that if you're a public company with widely held shares, that it's probably not okay. It's not okay to fake it until you make it. You have to be pretty forthright with investors. But I would be surprised. I'm sure that there are situations where there are lots of questionable activities, and a lot of them we just never learn about because the company ends up doing okay.
So here I'm going to tell you just my theory, and this is nothing more than a hypothesis. But my guess is that you're right, that there's been people who's like, okay, we're going to cannibalize next quarter's earnings. We're going to put them in here because I'll tell you what, this thing that we've been in R&D, sure, we cut the R&D budget because we had to meet expectations too, but we got this thing in R&D. It's going to kill next quarter. And then like you said, all their hopes and prayers come true. And the next quarter, it's like, this is the best quarter we've ever had. And this is my theory is they go, oh, thank God we pulled that off. We're never going to do that again. And then eventually they get in the same predicament and they go, oh, we did it the one time and it worked. So it'll, they're like up against the wall. Let's do it again. And then, so I think, so that's my guess, is that there's times where it has happened effectively, but if there hasn't been turnover in terms of the management, the next time they hit the same problem, they'll go, this worked before, let's do it again. And again, it's just a sustainability problem where you can't, God's not going to answer prayers twice. Listen, that's how jaded I am, is that you get one answered prayer and then it's over. That's it.
Yeah.
That sounds right, is that it can be dangerous. It can be dangerous, right? Sometimes it works, and then you try to pull it out again, and you get used to sort of cheating death, and
right.
at some point it catches up.
Yeah.
It might catch up with you. It might catch up with you. That's certainly certainly something I think that is a nice way of describing what must happen in many companies.
So, Jim, is there a case that didn't make the book that you think is just really good that either people don't know about, or it's just a classic and it got cut because it's like, oh, everybody's tired of hearing about this?
Right. Or
Well,
maybe
that's
even a case that did make the book, but it didn't get its own chapter. But you're like, this case really needs its own spotlight.
I guess the equity funding one is the crazy one that comes to mind about, they're literally making up. They have this separate office in Beverly Hills where, the job of these people was to literally fill out insurance forms that policies they claim to have sold to people who didn't exist. And, at one point, I think the auditors asked for 20 files and they're not able to produce them. But somehow they didn't follow up on it. It's a sort of a case that's near and dear to me because it happened in Century City, which is like 10 minutes from where I'm sitting, and that gets discovered by a whistleblower, and that's kind of an interesting new dynamic, as you know, with the SEC. They are giving awards to whistleblowers who can discover this stuff and report it. And the irony of this is that it led to this insider trading case, which is that he told the stockbroker told all of his clients and also the Wall Street Journal. And actually, equity funding was not pursued by the SEC, but the SEC brings an insider trading case against this research analyst, which was kind of odd, right? But it led to this case called Dirks, which is a very famous insider trading case, where the Supreme Court said that because the analyst didn't personally profit from the information, that they couldn't be guilty of insider trading. And that decision's been debated for like the last 30 or 40 years. So that's a big iconic case. The other one I would have included was Miniscribe, which you guys have talked about, shipping the bricks, and
Yep.
that was one that didn't quite make the cut. There's a slew. There are dozens of these things in the late 90s, early 2000s that one could have talked about. So there are a lot of examples that could have, maybe in another book or article I'll talk about.
Yeah. So the equity funding thing, the thing that you mentioned that made me chuckle was, the auditors requested like all these files from the clients and the clients just never gave it to them. Every auditor listening to this, right, I'm telling you, has that experience where they hand them a list of stuff that they need from the client and the client just never shows up with it. So that to the unfamiliar, that may sound suspicious, but I guarantee every auditor has that experience where like, they just never gave it to us. So like we never followed up. Anyway, so yeah, equity funding. I'm very interested in that story. So maybe we'll do a show on that someday, Greg. Okay. My last question. You mentioned at one point, I don't think you said specifically who, but you talked about a law professor who wrote an article called "What is Securities Fraud?" And anyone who reads about finance today reads Matt Levine at Bloomberg, and Matt has this recurring thing in his newsletter called "Everything is Securities Fraud." So I'm just curious, do you think we know what securities fraud is? So is the person that you're talking about, do we not know, or is Matt right and everything is?
It's really a great question, and it's something that I think lawyers need to do a better job of kind of explaining sort of what they're doing, and the SEC maybe as well. The "What is Securities Fraud" article was written by Sam Buell, who was a federal prosecutor, a very prominent a criminal law scholar who writes about various issues, and he's talking about sort of the vagueness of these various fraud statutes. And Levine's argument brings me to another subject, which is very, very hot right now, which is that you're getting more of these cases that are coming out of corporate disasters. Something bad happens to the company, reduces the stock price, and investors sue. And Matt Levine has sort of this running joke about this, and that ties in actually quite a bit with the ESG movement, which I'm sure you're familiar with, environmental, social, and governance concerns, and encouraging companies to act responsibly. The SEC is basically there now whenever there's a big corporate scandal. Like they are there. They filed and settled cases. The Boeing 737 Max crash, right? $200 million settlement. McDonald's has this scandal with its CEO. The SEC is there. Facebook had that Cambridge Analytica issue, and so there really kind of questions about, are we expanding the definition of securities fraud too much? My perspective is it just shows you how the idea of fraud evolves as the issues that are facing companies are changing. And I think the reason why you're seeing more ESG fraud cases is that companies are being pressured by investors to say more about their compliance and social responsibility. The more you say, then the more chances there are to argue that you said something misleading. Right. Because if it's true, investors care about these considerations in valuing companies, then if I'm misleading you about these ESG issues in a way, and I'm intending to deceive you, then that could be a securities fraud. So we're seeing the concept of securities fraud evolve. It's not static, and it changes over time.
Right. So even if from a legal standpoint, we don't know if everything is securities fraud, from a litigation strategy standpoint, everything is definitely securities fraud.
A lot of things, and the courts have tried to, develop barriers to some of the kind of more frivolous suits. And I think they're going to have to keep doing that because, the main question to me in these cases, I wrote an article on this called the ESG securities fraud. The main question is this the type of risk that we would reasonably expect managers to have some reasonable sense of what the risk is? Or is it just something bad that just happened out of the blue? You have some scandal in your company. Nobody really could have anticipated it. Is it that versus something where they have studied the issue and they know there's a high risk, but they tell everyone that it's a low risk, right? If they kind of know through their risk analysis, then that to me is a greater case for there should be liability versus it's just something that happens out of the blue that nobody could have anticipated. And then it's going to be up to the courts and the SEC to figure out how to distinguish between those types of cases.
Yeah, great.
I like what you're saying that with ESG, the companies are just saying too much. Where it's like, how's your environmental, social, and government? There, it's good. No further questions, and then they'd be fine. I mean, that's my takeaway. So, okay, my last question.
Yeah, final question, Greg.
My last question goes. We spoke about Under Armour earlier, and Under Armour, not my favorite company. I was wondering, Jim, if you're interested at all in this potential case against Under Armour, because I've found personally that Under Armour is not actually armor at all. I was wearing some, and my family and I, we have bow and arrows, and and I had my son shoot an arrow at me, and it lodged into my thigh where I had Under Armour compression shorts on, and it went through, and it caused me significant personal injury to my thigh and the infection that resulted from this dirty arrow that got shot in there. And nowhere on the packaging did it have any kind of disclaimer that Under Armour, despite the name, is not actually armor. So I'm not interested in a retainer kind of situation with you, Jim, but will you take this case on more of a commission basis, that if we win, you'll take parts, which we will, that you'll take part of the settlement for that case?
That sounds like an ESG issue, Greg. That's a consumer safety issue that they've misrepresented. So we'll have to look at their disclosures, and do they have a risk factor in their 10K that covers this? I'd like to see that. I'd really like to see that, and we would get some discovery and see if there's some internal emails that indicate they know about this risk. So we. A contingency basis might work fine for something like that.
I'll take it. We'll talk more off the mics, but thank you. I'm excited about that. I think I'm excited to pursue this with you.
Okay, that was great. That was really great.
Such a great conversation with Jim.
Yeah, super fun. I had more fun than I expected it to be good, but then I even had a better time. It exceeded my expectations. That's what I'm trying to say.
Yep. He was a fantastic guest.
He was. If you want to check out Jim's book or get in touch with him, there's links in the show notes that you can follow where to get the book or where to contact him through his profile on UCLA's website.
And that's it for this episode. So remember, debate team is a great launch pad for people who want to become lawyers, and the football team is a great launch pad for people who want to peak in high school.
I enjoyed that.
Did you not read that ahead of time?
Nope, I hate that. And also remember, an SEC internship isn't as sexy as it sounds. It's way sexier than it sounds.
If you want to drop us a line, like we said at the top of the show, send us an email at ohmyfraud@earmarkcpe.com. And Caleb, where can people get a hold of you if they want to find you?
I'm on Twitter or X. It's X.
It's X and Twitter. I feel like X still refers to itself as Twitter. So
does it? Oh,
yeah.
I've seen that. When it speaks in third person,
yeah,
it's like
yep.
Twitter's very upset with Elon Musk right now.
Exactly.
At C Newquist for the Xers,
yeah,
and / Caleb Newquist on LinkedIn. Greg, you've given up, right? No more internet for you, except for recording a podcast.
Recording a podcast and LinkedIn. Really, if through the social medias, LinkedIn's probably the best way to get a hold of me. But don't hold your breath for me to get back to you. I will eventually. I still look at it. I still look through all the stuff, but it takes me a little while. But yeah, LinkedIn, Greg Kyte CPA. That's me on LinkedIn. So check me out there.
Oh My Fraud is written by Greg Kyte and myself. Our producer is Zach Frank. If you like the show, rate it. Write a review, share it with a friend. It's the right thing to do. It's a nice thing to do. And subscribe on Apple, Spotify, wherever you listen, iHeartRadio. Podcast Addict is another one, apparently.
Nice. Earmark CPE is another one.
Earmark is another one. And you can get CPE if you listen on Earmark.
Yep.
And I don't know when this show is going to be released, but chances are, right now, if you're listening, you might need some CPE.
You do need some CPE.
All right. Join us next time for more avarice, swindlers, and scams. From stories that will make you say, oh my fraud.
Oh my fraud.